our presentation today, Uninvited Guests, What to Do When the Government Comes Knocking. We'll cover the current state of white-collar criminal enforcement, strategies for responding to some of the common government inquiries that you and your clients might receive, and also considerations for when you might want to reach out and call the government yourself. So trying to look at the problem from a couple of different angles. So just some brief introductions. I'm Brook Dooley. I'm a partner here. I've been a partner for about 15 years. In addition to my civil litigation practice, I represent individuals and companies in connection with government investigations. That's everything ranging from DOJ grand jury investigations, SEC enforcement actions, all the way to state and local civil investigations. So that's me. And Cody, why don't you introduce yourself?
Sure. Hello, everyone. My name is Cody Gray. I'm a partner here at Keker. And like Brook, my practice is kind of a combination of civil litigation and white-collar criminal defense work, mostly representing individuals, but also representing companies. And I'm also a member of the Northern District of California's Criminal Justice Act panel. So I do a fair amount of work representing indigent defendants in federal criminal cases in the Northern District of California. So love this work. Happy to be here today. Excited to talk to you guys about these issues and looking forward to it.
I'm a little worried that if I keep following Brook and Cody, they're going to say everything, and I'm just going to say me too. My name is Nic Marais. I am a partner here at KVP. I've been here for about 15 years, and in that capacity, I've had the pleasure of working with some of you whose names I see in the chat. Hopefully, we'll work with the rest of you in the next 15. I have a pretty consistent mix of civil and criminal work. Like most of the lawyers at our firm, my civil work really runs the gamut: class actions, contract disputes, startup disputes. Spent a lot of last year working on a wrongful termination dispute. So if it's interesting and it's difficult and it's important to you, we're here. The criminal work is, as Cody said, also somewhat wide-ranging, which is a little surprising for a firm like ours. All of us do a fair amount of white-collar criminal defense work. Cody and I have both done some cases over the last few years for the CJA panel, which tends to be indigent defendants who have all manner of different problems. So that's me. I'm very glad to be here. I'm looking forward to maybe talking with some of you. If you have questions as we go, please let us know, and happy to work with any of you in the future, hopefully on the civil side, but you never know.
Great. Briefly, what's our agenda? We're going to, Cody's going to start things off by talking about the current landscape of white-collar criminal enforcement, both sort of nationally and also here in the Northern District of California. There's a lot to say on that topic, and we'll certainly welcome questions that folks have. It's been a very dynamic time in white-collar criminal enforcement. A lot has changed with the current administration. And so Cody will walk us through that discussion. And then Nic will talk to us about what happens when the government calls you. This is the uninvited guests reference in the title of the program. And we'll talk about, Nic will talk about some of the familiar tools the government has to obtain evidence that you might be confronted with, whether it's a document subpoena, it's a grand jury subpoena for testimony, in the most extreme case, a search warrant, and talk about the risks that go along with those different tools and then some strategies for dealing with them. And then at the end, I'm going to talk a little bit about the other side of the coin. When might you call the government? And we'll look at two scenarios in particular. The first being, what happens if your company or a company you're advising is the victim of crime and you want to, or you're thinking about calling law enforcement to get their assistance? What should you be thinking about? What are the benefits and what are the risks of getting law enforcement involved. And then we'll also talk about what happens in the unfortunate event that you discover wrongdoing within your company, and how can you think about the question of whether to self-report that conduct to law enforcement. What are the things to be thinking about? What are the benefits? What are the risks? And what are the benefits of self-reporting? So, and then time at the end for questions, but please fire away as we go. These things are always better the more interactive they are. That said, we promise we will not cold call on anyone. So with that, Cody, why don't you dive into the current landscape?
I'm happy to do that. So thanks, Brook. So in talking about the current white collar landscape, the biggest takeaway is that there's a decreasing focus on white collar crime. I think the American Bar Association's white collar conference happened in the last week or two down in San Diego this year. And just the recurrent joke everyone was making is just, is there still any focus at all on white collar crime, or do we still have anything to do? And it's a little more complicated than that, but the big trend is that there's a decreasing focus on it and cases are declining. So why don't we go to the next slide? This puts a little bit of data behind where we are today in white collar enforcement. So the Department of Justice tracks the types of cases that it files each year. There's a nonprofit that puts all of that together into reports and charts. And just to give you a little context, the Department of Justice classifies white collar crime as consisting of most corporate and consumer frauds, things like wire fraud, bank fraud, federal program fraud, healthcare fraud, tax fraud, identity theft, securities fraud issues, antitrust crimes, things like that. And the latest government records reveal that 2025 continued a long-term decline in white collar prosecutions. So the chart might be a little bit difficult to see, but the numbers peaked most recently in fiscal year 2011 under the Obama administration. And back then, there were about 10,000 white collar prosecutions that year. Since then, they've steadily been going down under administrations of both parties. They're down to under 4,000 in the last year, which is about 10% less than fiscal year 2024, which was the last full year of the Biden administration. So the Trump administration is continuing this downward trend. If you're following the news at all, it won't surprise you that this downward trend is likely to continue. One reason for that is that the FBI is the lead investigative agency for white collar prosecutions. They originate most of the cases. That's been true for a long time. And as you may know, the Trump administration has been cutting resources for the FBI and directing the FBI to focus on immigration enforcement and to deprioritize white collar crime. And so when you combine that development with the significant number of departures, both voluntary and involuntary departures from both the DOJ and the FBI, what we're seeing is a general overall decline in prosecution rates, other than for, you guessed it, immigration-related offenses and things like that. But certainly in the white collar space, a marked dip in white collar prosecutions. Of the white collar cases that are being brought, the records show that they're still overwhelmingly focused on individuals rather than corporations, but there's still a mix of both. And so we're going to talk a little bit more about that. So thank you, Amy. So the next slide here, I want to zero in just a little bit on this category of the white collar prosecutions that are being brought. And the question is, what are the second Trump administration's priorities in this space? Well, they issued a memorandum on that specific topic in May of last year. It was authored by this guy here, Matthew Galati, head of the criminal division. And I think it's worth noting that this memorandum took a pretty soft tone, frankly, on white collar enforcement in general. And let's look at the next slide. So the memorandum laid out the criminal division's enforcement priorities, but it also said in very clear language right up front, overbroad and unchecked corporate and white collar enforcement burdens U.S. businesses and harms U.S. interests. The vast majority of American businesses are legitimate enterprises working to deliver value for their shareholders and quality products and services for customers. Prosecutors must avoid overreach that punishes risk-taking and hinders innovation. So when I see this, the TLDR of this memo to me is that the administration is going to identify some areas that it expects to focus on, but white collar enforcement in general is just not a major priority for this administration. Okay, let's look at the next slide. So all of that said, what are the areas that the DOJ is saying it will focus on for the next few years? Well, they specifically identified 10. The first is waste, fraud, and abuse, including healthcare fraud and federal program fraud. And the memo specifically calls out fraud related to Medicare, Medicaid, defense spending, and other programs intended to assist vulnerable citizens. The administration also highlighted trade and customs fraud. That's about individuals who commit tariff evasion, fraud perpetrated through variable interest entities. And so the DOJ describes those as, quote, typically Chinese affiliated companies listed on US exchanges that carry significant risks to the investing public because they provide few protections to investors and can be used to perpetrate fraud in the US markets. That's what we're talking about there. Broadly, just fraud that victimizes US investors. On that one, the memo specifically calls out Ponzi schemes, investment fraud, elder fraud, similar issues. That's actually one of the only references to kind of bread and butter type fraud cases that you see in a lot of US attorneys' offices around the country. Some of the other topics, material support by corporations to foreign terrorist organizations, complex money laundering schemes, again, specifically including Chinese money laundering schemes. That's a focus of this administration. Drug crimes, violations of the Food, Drug, and Cosmetic Act. There, the administration is saying that it's going to focus on the unlawful manufacture of drugs used to create counterfeit pills and the unlawful distribution of opioids. So that's sort of about the administration's effort to address opioids. Bribery and associated money laundering that impacts U.S. national interests. That's a reference to the Foreign Corrupt Practices Act, the FCPA. As you may know, the Trump administration paused initiation of new FCPA cases in February of last year, just kind of put a complete pencils down on that, and then issued new guidance in June of last year that spelled out kind of what prosecutors should be thinking about and considering in FCPA cases going forward. And now in the second half of last year and the beginning of this year, we're again starting to see FCPA cases being brought and being a greater focus of this administration. So they're saying that's another thing that they're focused on. And then the last one here is crimes involving digital assets that victimize investors and consumers. This is kind of a nuanced one. The administration is saying that it will continue to pursue traditional fraud that involves digital assets. But as you might know, it walked away from several high-profile cases that the Biden administration had brought against various crypto exchanges in their leadership. And those were cases that claimed things like that these exchanges were offering unregistered securities or that they were violating the Bank Secrecy Act. The administration has stepped away from all of those cases. They, are portraying themselves as very pro-crypto. They are trying to get away from a posture of regulation through enforcement actions. And so they are still willing to pursue fraud cases that involve digital assets, but aren't going to be trying to create crypto policy through enforcement actions. Okay, so those are the areas of priority. What's the takeaway? I mean, my takeaway from these 10 areas is that the DOJ is focused on crimes associated with foreign policy, with immigration enforcement, international affairs, generally less focused on things that are part of the standard white collar prosecution areas, frankly, tax fraud, wire fraud, securities fraud, bank fraud. Those cases are still likely being developed in individual U.S. attorneys' offices, but not necessarily a focus of main justice. Okay.
There's a
So let's look at
question in the chat, Cody,
Yep.
if you want to take it.
Oh,
That says, so can we assume that the government is not going after situations of strict liability where a company officials may inadvertently violate a law or regulation due to ignorance of personnel or unintentional mistakes by staff lower in the company pyramid. Is the government focusing on intentional violations? I know that government has in the past used ignorant businesses to set an example.
Yeah, I would say that the administration in general is not focused on strict liability offenses. They are very much focused on prosecuting individuals for knowing violations of the law. They're not very interested in prosecuting companies, frankly. I think Brooke is going to talk a little bit about that. I have a little bit about that as well. But certainly the priority, as we're going to get to in this presentation in just a minute, is to focus on prosecuting specific individuals who knowingly engaged in criminal wrongdoing.
I have a reaction to this question, which is, I think in a world where there are fewer prosecutions, but they are more idiosyncratic, I would probably be more concerned about the issues raised in this question than I might have been in the past. I think the priorities Cody's talking about change from office to office, which has always been true, but I think it's more true now than ever before. And they change on a dime and on a whim, and a company that is in favor today may not be in favor tomorrow. And my view on wire fraud cases has always been that if you take a magnifying glass to pretty much any company anywhere, you can find enough to make a case if you're motivated to do it. And I think there is more motivation randomly, less in aggregate maybe, but that would be my concern.
I think that's right. Completely agree with that. But I do think this administration is pretty focused on prosecuting individuals, basically individual wrongdoers, and kind of going a little easier on companies, frankly. But we're going to get to that. So let's look at the next slide. There were two kind of countervailing forces that I just wanted to briefly mention that might be seen to kind of be pushing against the overall decline in prosecutions and white-collar prosecutions in particular. The first is that last month, the president established an intergovernmental task force focused on eliminating fraud. It's headed by the vice president himself. It reports directly to President Trump. It's expected to focus on fraud in federal benefit programs. This kind of came out of the administration's concerns about what it perceives to be happening in Minnesota. It could theoretically allow agencies to work together on more complicated investigations, which again could theoretically provide an infrastructure for more white-collar investigations and prosecutions in general. So, something to keep an eye on. Let's look at the next slide. Related to that is that the government has established a new position at DOJ, the Assistant Attorney General for Fraud, and earlier this week, I think on Tuesday, confirmed the president's choice for that position, which is a former prosecutor named Colin McDonald. He's reportedly going to run a new National Fraud Enforcement Division within the DOJ that's going to be looking at fraud across the country. I just highlight this again as another piece of infrastructure for coordinating resources that could potentially go towards building more complex white-collar investigations. You really need that infrastructure to build a white-collar case. There's been a ton of brain drain, a ton of lost institutional knowledge at DOJ in the last 12 months, and this is potentially something that could restore a little bit of the ability to bring a complicated white-collar case.
Cody, just to jump in there, I mean,
Yep.
I think just to sort of articulate what I imagine a lot of folks are thinking, which is that the term fraud is broad enough to include what you might think of as traditional, legitimate wire fraud, mail fraud type prosecutions, and government program fraud, et cetera. It's also broad enough to encompass some of the current administration's more politically driven initiatives. And so I think the jury is out on where this new fraud department and this new fraud task force will be focused. And I think you're absolutely right that it could be a means for revitalized white-collar enforcement, traditional white-collar enforcement but it could just as easily be a avenue for some of the more politically driven investigations that I think we've seen over the last year.
That's good. I think that's totally right, Brooke. I think, just the reporting on this recently has focused on the potential to bring things like False Claims Act cases. The administration, probably not a surprise to anyone listening on this call, is focused on things like DEI policies and, perceived anti-Semitism on college campuses and things like that. And, this is being reported as a potential infrastructure to pursue False Claims Act theories with different kinds of institutions, impliedly false certifications that were made related to, benefits received from government programs and things like that. Completely remains to be seen where this will go, but certainly notable that they're setting up this kind of infrastructure at DOJ and in the government more broadly now. Okay, let's keep going. So I just wanted to touch briefly that this memo explicitly makes clear, as we were saying earlier, that the department's priority is to prosecute individuals. It actually states that prosecutors should prioritize schemes involving senior level personnel or other culpable actors, demonstrable loss, and efforts to obstruct justice. And so those are, this isn't too different from what we've seen in other administrations, but certainly they're focused on individuals. If we look at the next slide, the question is, well, what about the companies that those individuals work for? And the administration's taking the position that individual prosecutions are often enough for low-level misconduct, and that prosecutors must consider additional factors when determining whether to charge corporations, including whether the company reported the conduct to the department, its willingness to cooperate with the government, and its actions to remediate the misconduct. And so, again, one takeaway here is that the DOJ is focused on incentivizing corporate cooperation. I think Brooke's going to get into some of the details of what that might look like later. But just to hammer down that point, let's look at the next slide. About a month after DOJ issued this memo, Mr. Galati gave a speech talking about what the administration's priorities are in the white collar space. And the thing that he really focused on was cooperation. He says here, the benefits to companies that voluntarily self-report, cooperate, and remediate have never been clearer and more certain. Those companies will receive a declination, not just a presumption of a declination. That means, they're not even going to bring a charge. The memo, the administration has separately issued guidance about cooperating with the DOJ, and even in kind of, quote, near miss cases, they're willing to do things like non-prosecution agreements, deferred prosecution agreements. And so, this administration is very focused on corporate cooperation. So what does this all mean for you and your company? Well, you may receive unwanted government attention. The attention may be focused on rooting out some kind of fraud, wire fraud, tax fraud, fraud involving some government program, misappropriation of some kind, trade secret misappropriation. The attention could come in the form of document requests, subpoenas, requests for interviews, search warrants, all the things that Nic is going to talk about. And those sorts of things come with a lot of risk to your business. It can disrupt your functioning, it can disrupt your operations, impact employee morale, tarnish your reputation, impose financial damage. So you need to be careful in navigating the government inquiries that you might receive so you can avoid this sort of detrimental impact to your company. And, that's what we're going to talk about next. Quickly before doing that, I just wanted to close out this section by talking about one notable example from our backyard. So Amy, let's look at the next slide. Late last year, the DOJ indicted a company called Dunn Global Inc., which is a telehealth company based in San Francisco, or based in the Bay Area and also based in China, that the government contends was illegally distributing prescriptions for Adderall over the internet. And I think this case is kind of, it happened here in San Francisco. The CEO was also charged. That case was before Judge Breyer. This case, I believe, is also before Judge Breyer. It's kind of emblematic of the kind of prosecution the DOJ is at least saying it is focused on at the moment. It's a healthcare fraud case. There was alleged wrongdoing involving the most senior personnel at the company. They charged the CEO. She was actually convicted after a 3-month trial. They brought obstruction of justice charges against both the CEO and the company based on allegations that documents were being destroyed or at least not properly retained, something that you really, really need to get right in a white-collar investigation. And the company's case is ongoing. The CEO was convicted. She hasn't been sentenced yet. That's still to come. Company's case is ongoing, but needless to say, when you receive outreach from the government, you need to know how to respond. You need to know how to handle it. And so that's what Nic is going to walk you through next.
It's funny how we're still talking about things like ephemeral messaging and the risks of obstruction of justice charges. I feel like every year we add more issues. I'll talk a little about AI, for instance. We add more complications to criminal defense work without actually subtracting any, unfortunately. Let me just say 3 quick things up front, and then we can talk a little, as Cody said, about the nuts and bolts of criminal procedure. The first is I have the 101 section of this presentation. I'm going to try to keep things pretty basic. I don't know all of you. I don't know what level everybody's at. But if you have more questions, you want to talk about any of this to any of us, we're always happy to do it at much more length and in much more detail than we can get into in the course of this presentation. The second thing is a lot of this stuff is pretty rare. You know, the chances of your company, your client getting a grand jury subpoena, let alone a visit from the FBI with AR-15s, it happens, but it's relatively rare. And so we're kind of flagging things to be thinking about and things to be concerned about, because when it happens, the consequences are really significant, and you need to know what to do in that moment when somebody arrives with a search warrant. But I do just want to say at the outset that the chances of that happening, I think, are fairly slim for most people. And as Cody says, slimmer now than they have been in years past. And the third big point is, I'm going to say this a lot in the next 10 minutes, but a lot of this stuff is very tricky. The strategic calls about when to engage with the government, whether to engage with the government, how to negotiate what you're going to give them or what you're not going to give them. The extremely complex strategic calls Brook's going to deal with about whether you want to voluntarily engage with the government and take on the risks of that spiraling out of control. The questions are very, very tricky, and often the answers are very hard. And this is not like, you know, civil cases are tricky in their own way, and thinking through your strategic options is always critical, but you don't get sent to prison for making misstatements in a deposition. You know, the stakes are just very high. And so a lot of what I'm going to say is just think about these issues, be aware of these issues, and know who it is that you want to call. I mean, have somebody that if things go south, you're able to call and talk to. I'm lucky that I have lots of those people in this building. Some of them are on this call, but you know, just know who it is, that when you find yourself with your back against the wall, you have somebody that you can turn to, because those situations are both complicated and obviously very difficult to deal with when they're your situations. So, Amy, we could probably go a couple slides ahead, but the instinct that I think most people have when engaging with the government is to move quickly, and that is almost always the wrong instinct. So too the instinct to try to be cooperative and to go in and to explain everything. A lot of our human instincts are the wrong instincts when it comes to the world of criminal defense. What you need to do if you get a request, and these requests that we're talking about at the beginning are subpoenas, is assess where it's coming from. Maybe an informal outreach from somebody, but is it the Department of Justice? Is it a visit from the FBI? Is it the SEC? Is it any number of other agencies in the federal government? Is it a state AG? It's a really important question, because Cody's given you some sense that different places have different priorities. It will tell us a little about what it is they're investigating, why they're investigating it. It will tell us a little about the seriousness of the investigation. You know, historically, traditionally, federal government investigations tend to be more proactive. People are a little further out in front of things rather than reacting to things they see in the news. But knowing where the request is coming from will tell us a lot about the nature of the request and also how it is that you want to deal with it. The second thing you're going to learn from a subpoena, maybe, hopefully, is who the government is actually investigating. A subpoena that asks for your email communications with Acme Corporation is very different from a subpoena that asks about your FCPA policies and your executive's travel history for the last 4 years. So drilling down on the substance of the request is going to tell us, hopefully, something about what's going on. The third is obviously the nature of the request. We'll talk a little bit today about subpoenas. That gets escalated sometimes to grand jury subpoenas. Again, we're going up the pyramid. Things get rarer and rarer. In my experience, the government is not typically eager to put somebody before the grand jury before they know what they're going to say or have had a chance to talk to them. So that normally starts as a more informal process. But you could find yourself with a grand jury subpoena for witness testimony, and in the worst case, you could be looking at some kind of search warrant. So the nature of the request is important, and obviously when it's due is going to light a fire to make sure that you have the right folks engaged. Subpoenas in particular are not hard and fast. They're often negotiable. We do negotiate them all the time. There are ways of slowing the process down. I tend to try and work with the government on a subpoena to work out what their high priority items are. Hopefully there's a way to get their high priority items to be the things that my clients don't care all that much about handing over. And I find that you can phase discovery with the government. So sometimes we'll offer to, why don't we start by producing emails between X and Acme Corporation? You guys take a look at those. And if you think you need more, we'll have another discussion about what it is you need. It is a truth about the federal government that they can be very slow to engage in an iterative process. And so I find that delay is often hugely helpful. Okay, next slide. Thinking about your response obviously implicates all sorts of concerns. You don't have to, you're not giving up your privilege. You don't have to hand over privileged documents. We'll talk a little about the scope of privilege, but just generally speaking, you can negotiate the scope of the subpoena. You can talk to the government, especially if it's kind of a regulatory investigation about confidentiality protections for sensitive documents and trade secrets. Whether you can trust folks on that is a whole different question. I'm litigating a very silly motion in New York at the moment, where the government asked us to produce, the state government asked us to produce documents. We agreed to do it subject to a protective order. I thought we were all on the same page, and now they're actively opposing a pretty straightforward motion to seal to try and get those documents into the public record in connection with proceedings that they have going on over there. So there's some scope to how much you can negotiate, but this part of the process looks a lot more like civil discovery and is certainly susceptible to more negotiation. A word of caution, obviously, is making sure that what you've negotiated and what you've agreed to produce is well documented, because you don't want somebody coming back later and saying, well, you responded to a broad subpoena with a narrow set of documents, and we now feel that you were hiding information from us that you should have provided. Next slide. We've covered a lot of this already, but a subpoena is negotiable. The company doesn't have Fifth Amendment privileges. Company documents aren't protected under the Fifth Amendment, but your employees' information may be, or their testimony may be. Individual documents, it gets pretty complicated. But these are all issues that I think you want to be thinking through in dealing with the subpoena. Again, you have time to do that. A word on privilege. Some of you will have seen the news out of SCNY last month. Jed Rakoff was asked to rule on a privilege issue about communications with an AI platform. An individual had been, I don't know if he'd been indicted, but he was aware that there was an investigation going on. He'd hired outside counsel. He had used an AI platform the way many folks do to ask questions about his legal strategy and his culpability, and had then sent that information back to his lawyers, who tried to resist producing it to the government, as you would, on the basis that it was privileged and had legal information. the court was not interested, basically because the AI platform in question had terms of service that made clear that the information was non-confidential, and that platform might turn it over to the government if the government came to ask for it. And so none of that information was confidential, and it all had to be disclosed to the government, which is pretty close to catastrophic. So I'm now having conversations with all of my clients, and certainly with all new clients, about where they're, as we always used to, but now with a particular focus on the risks of AI, and talking about their case with other people. Amy? Yeah, John's posted the site. Thanks. Yeah, it was Bradley Hepner, and I think it was Claude was the AI platform, but it's worth looking at. Okay, this is sort of just a basic checklist if you find yourself dealing with a subpoena from the government. It's not worth haggling over service, obviously. Engage counsel that you trust, and trust to handle this as quickly as you can. You hopefully already have document preservation policies in place, but you want to get a litigation hold. You want to think, as Cody said, about ephemeral messaging issues. The Dunn Global case that Cody was talking about, there was an obstruction charge based on auto delete set on one of the messaging platforms, WhatsApp or Signal. I alluded to this at the beginning. We're all still trying to work out what's allowable, because we all still have plenty of clients who are using WhatsApp and Signal and who have auto deletion policies. We all still have auto deletion policies on our email. I think the bright line is, are you aware, and this was the allegation in that case, are you aware that there is an investigation into your business? Have you received a subpoena from the grand jury? That changes the stakes, obviously, as to whether your auto delete functions are appropriate or not. And again, in that case, there was some argument of knowledge of culpability based on adding auto delete functions after knowledge of an ongoing investigation. You can, as I said earlier, negotiate the scope of your response. We do that all the time. You can tell the government which custodians you plan to use. I mean, as in civil discovery, you want to be a little careful about giving them a roadmap as to who they might ask to interview. You can negotiate search terms. I mean, a subpoena in this context is very much like a civil subpoena, and candidly, the government state AG's offices can sometimes be much more reasonable about the scope of the request, and willing to negotiate them than our opposing counsel in civil cases.
Nick, can I just make one comment on documents before we move on?
Yeah, please.
So, it's not just the case that when you receive a subpoena, the question is, we're going to respond, and how much are we going to respond? You can negotiate the scope of the request, but the response might be that we're not going to respond at all. I mean, so you can initiate litigation, you can move to quash a subpoena, and I think it's just it's worth flagging that that's been happening with increasing prominence in this administration. And so, we happen to represent a children's hospital in one of the cases that we're working on. I see my colleague Asim Mehta's on the call too. We're representing a children's hospital that got a subpoena for some records, and we challenged that subpoena in a motion to quash, because in our view, the subpoena was issued for an improper purpose, and the government's entire investigative theory was invalid, wasn't based on a viable legal theory. That litigation's ongoing, but there have been a number of decisions on that specific issue that have gone in defendants' favors. And you're seeing this again even more. The most recent one was that the Federal Reserve Board received document request subpoenas from the DOJ in connection with a putative prosecution. And, our former colleague, Jeb Boasberg, actually quashed that subpoena its entirety recently, again, finding that it was issued for an improper purpose. And so, when you get a subpoena from the government, certainly you want to think about your options. You want to think about what makes sense for you. You can negotiate the scope of the request. Sometimes the decision might be that the request in and of itself is improper, and you want to just go to court and fight it.
Amy, can we go to slide 22? I think I lost the slides altogether.
While we're calling up the slides, I'll just double click a bit on Cody's comment about the viability of challenging subpoenas and document requests, CIDs, et cetera, in the current environment. That has always been a very difficult road to go down in the past. However, with the increasingly aggressive prosecutions that appear to have political motivations, courts are, and not just in the context of the gender affirming care subpoenas, but in other contexts, courts are increasingly willing to hear those arguments and give them consideration. I mean, that extends to motions alleging government misconduct as a basis to dismiss indictments. For a very long time, those have been in the nature of a Hail Mary type motion. Now they're getting more consideration given the types of prosecutions that we're seeing. All of which is to say there are more tools available that really weren't realistic options previously.
Well, I think it also used to be much harder to prove that there was an improper motive for the subpoena than it is these days.
Certainly, the government's saying the quiet part out loud.
Yeah, and I think that's the first line of Judge Boasberg's decision that you're alluding to is quotes from one or another Twitter feed. Let's talk a little bit about testimony, because this is probably the next most likely place on the 101 nuts and bolts that you're going to bump into, which is a big question of whether you want individuals to go in and talk with the government. I mean, there's a version of this that happens within your control, and there's a version of this that happens outside your control. And I think the latter is the one you should probably be thinking about in that category of unlikely, but very risky. And that is, what happens if the FBI shows up at somebody's door at 6 o'clock and everybody's tired and they're home from work, and sometimes the FBI is quite friendly and they just want to have a chat about something. And folks don't get any warning, you don't get any notice, you don't get any of the information that you're getting on this slide about what you can and can't do. And the answer to that is relatively simple. You politely say, thanks, I'm not interested in talking. Why don't you call my lawyer, or let me get back to you tomorrow. I'll take your business card. But you can get into all of the same problems in that informal setting as you can in the formal setting, just without really being aware of it. You have the same concerns about testimony as we've been talking about with documents. You have privilege to look out for. You want to be thinking about confidentiality of your information, about trade secrets, about what it is that the government's going to ask. Sometimes you can talk to them about that in advance. Sometimes you can't. You have additional problems in testimony, which is, and a lot of people, as you know, get tripped up under Section 1001, which is making a false statement or a material omission to a federal official. And there are any number of cases that any of us could talk about for hours, from Greg Craig, who's talked about here, to Martha Stewart, to Barry Bonds, or people who, Martha Stewart was, I think, accused of escaping $45,000 worth of losses on a stock trade based on material non-public information, and went down for misstatements to the feds, and ended up spending 4 or 5 months in prison over that. So, and a misstatement, I said earlier, is like in a deposition, it's relatively easy to say something that it turns out is false because our memories are unreliable and we're confident about things we shouldn't be confident about. It's just the stakes are much, much higher when you're meeting with the government. Next slide, Amy. As with subpoenas, testimony is generally kind of within your control. Employees don't have to sit down with the government, and if they want to, you can negotiate the scope of the interview. You risk a little bit your credibility. You risk increasing your exposure, and that is one of these very difficult decisions that you have to make. I had a case last year or the year before with a client who was adjacent to a fraud, in my view, was as much a victim of the fraud as anybody else. But the government's view was that this person had been a little negligent and should have tried harder. And and should accord it. And you have to make a very difficult decision about whether you want to have that person go in and talk to the government and explain their side of the story. Sometimes that gets the government to back down. Sometimes they say something in that interview that leads to a whole new line of investigation that you would rather not have had anybody look into. So in that case, and this is more often than not how I handle it, we did not go in. We did not talk to the government voluntarily. We did not get a grand jury subpoena. We did not get indicted. But those are difficult decisions that you have to think through. So that's testimony. I'm not going to say any more than I have already about search warrants. You know, they're rare. It's unusual for the government to show up at your door, although not impossible. My primary recommendation on that is just know in advance who it is that you're going to call. Brook?
Thanks, Nic, and thanks, Cody, for setting the stage. We're going to flip here and talk briefly about kind of the other side of the coin, which is instances when you might be considering calling the government yourself. There we are. We've got the guy walking into the IRS office here with his hands up. He's surrendering. Go to the next slide. The first scenario is, you've got a company that you're in-house, or you're advising a company that believes it is a victim of a crime, whether it's trade secret theft, fraud, hacking, what have you. The company perceives that it has been a victim of a crime and needs to decide whether to go to report that to the prosecutors, law enforcement. Some factors, some things to think about. Is there an obligation to report? So there may not be a question to be answered, because you may, for example, if you're in a regulated industry, or if there's a particular a statutory requirement, a regulatory requirement that you report, you may not have any decision at all. Your reporting may be required. You ought to think about the nature and scope of the wrongdoing that you've uncovered. One reason to do that is law enforcement resources are limited, and what you believe is a serious crime that warrants the attention of the U.S. Attorney's Office, the FBI, or the local district attorney, they may not share that view. And so certainly have represented victims of crime, where the victims thought the crime was serious, law enforcement did not share that view. And so we had a very frustrating time putting in a lot of work, trying to communicate the seriousness of the situation and getting no traction. And so I think it's really worth upfront thinking about how well how interested is law enforcement going to be? Relatedly, does a crime involve an issue that is of particular relevance to law enforcement? Does it hit on one of the areas that Cody identified earlier as being focuses of the current administration? Do you have good evidence of the crime? I mean, the government is going to be materially less interested if the evidence of the crime is shaky. But if you've got really, on the other hand, really good evidence, you're going to get more traction. How is the company involved? I mean, this involves an assessment of, is the company truly a victim here, or does the company have some exposure? Are you really in this victim category, or are you in the next category that we're going to talk about, where you're potentially a cooperator self-reporting criminal conduct that your company or your employees have engaged in? Who has jurisdiction? Where are you going to take your report? And then who should do the reporting? Is this something that in-house counsel can handle, or is this something that it makes sense to bring outside counsel in? And that's often a question of scale and complexity. Once you've reported a crime and you've engaged with law enforcement, it's likely that law enforcement's going to have follow-up requests. They're going to want to do interviews. They're going to want to collect documents. There's going to be a back and forth as part of your cooperation or as part of your reporting, and it may take time. It will take time to engage in that. And is that something that your in-house team has the capacity to do, or does it make sense to bring in outside counsel? That's one consideration. As Nic said earlier, these are very complicated issues, and this is not intended as a cover the waterfront assessment of the things that you need to have in mind, but rather to flag some of the key issues and assist in your issue spotting and thinking as you approach this decision. Let's go to the next slide and talk about what the benefits are for calling the government in this scenario where you're the victim of a crime. And a lot of this is self-evident, but it's worth thinking through as you sort of weigh the benefits and risks of reporting and identifying as a victim. I mean, one big benefit is the restitution and remedies. The government, through prosecution, can obtain restitution for victims, and that's a powerful incentive to bring your case to the government and have the government pursue a criminal investigation. A pointer there is if you are considering, if you discover that you're the victim of a crime and you're considering reporting that to law enforcement, start making a record of your expenses. What are you paying for your lawyers? What are you paying for remediation? What are the costs that you've incurred? Because those costs could very well be recoverable. Expanded investigative tools. The government has more power than private litigants do to obtain evidence, whether it's through search and seizure, computers. They have a greater jurisdictional reach. They've got greater ability to get information from institutions like internet service providers. The government also, frankly, just has a better ability to get informal compliance with document requests just by the nature of the fact that they're the government and they're prosecutors, and folks tend to want to do what prosecutors ask them to do. And all of that may be beneficial to the company, particularly, moving to the next point, if you are in civil litigation around the crime that you've reported. You may be able to get the benefit of the government's investigation, their enhanced tools, and use that investigation to enhance your position in civil litigation. There's also benefits to deterrence benefits. Reporting folks to the authorities sends a strong message to other would-be wrongdoers that may well deter them. And you may also get a benefit in the press or in public relations by clearly identifying the wrongdoing that happened as something that was somebody else's fault. Your company was not at fault. You were the victim, and that can have benefits. If we go to the next slide, we can talk about the risk. And a lot of this is just the flip side of the benefits, but it's important to think about because I think there's, in this regard, when you perceive yourself or your company or your client as the victim of a crime, it almost can seem like a no-brainer. Well, let's call the police, let's call the DA, let's call the FBI. But there's some real downsides, and a big one is the loss of control and timing and direction of the investigation. When you've got a civil suit, to a certain degree, you are in charge. You make decisions. You control the pace to a degree, of course. Once you've handed this over to the FBI, the U.S. Attorney's Office, the local DA's office, they're driving the bus, and it's out of your hands to a certain degree. It also opens the doors to the investigators. Once you've brought them in to your company to look at what you perceive to be this crime, they may find other things that they want to look at. And it's very hard to stop that process once law enforcement is investigating and is looking at your company. It's very hard once they've said, hey, we're here to investigate topic A, but we're interested in topic B, it's very hard to shut that down. We talked about the benefits to civil litigation that a parallel criminal case can have. There's also detriments. One example is a stay. Oftentimes, prosecutors will seek to stay parallel civil litigation if there's an ongoing criminal investigation, and that can end up slowing your civil case down while the criminal case proceeds. Potential for privilege waiver, could probably do a whole presentation on that alone, but complex issues arise when you have an internal investigation of whatever nature, collecting documents, interviewing witnesses, and then providing that to the government to further its investigation. That can be deemed a waiver. That can have knock-on effects in the related civil litigation. And so you just need to be aware of that possibility and structure your interactions accordingly to minimize either the fact of a waiver or the impact of a waiver in terms of what gets disclosed. And then, of course, time, expense, distraction. It's time consuming to deal with the government on these things, and increased press and publicity. This is, again, sort of the flip side of what we talked about a moment ago. Making something into a criminal case may call more attention, undesirable attention to the issue, and may make the problem worse from a public perception angle than if you had either dealt with the matter internally or dealt with it through civil litigation. So bottom line, if your company, if your client, it perceives itself as a victim, there's a lot to think about before you pick up the phone and call the FBI. And as I think Nic was saying earlier, these are strategic questions that really benefit from some patient thinking through and really going slow as you make those decisions. I'll just talk. I know we're very close to out of time, and I want to give everybody a break. But the next scenario is the situation where, and if we can go to the next slide, where a company perceives that wrongdoing has happened within the company. So you're not a victim, but rather one of your employees has engaged in wrongful conduct, and the question is, do we report this? Do we self-report this to the government? And a lot of the factors that you're going to think about are the same as in the context of being a victim of a crime. Is there an obligation to report? What's the scope? Is this a high-level individual? Is this a lower-level individual? Can we cabin this, and can we characterize this as kind of, hey, there's just this one bad apple? Is it systemic? Those are all questions that you're going to want to grapple with because obviously the higher up the problem goes, the larger the problem is, the more systemic the problem is, the consequences of self-reporting become greater because you are telling the government that you did something, that your company did something wrong. And so careful consideration needs to be given to understanding the scope of the problem. Likewise, you're thinking about the potential for civil litigation, and you're thinking about the extent of the investigation that you need to do before you go to the government. Do you do a full-blown internal investigation before you self-report, or do you wait on that? Lots of considerations there. Last slide, kind of thinking through the risks and benefits of self-reporting. The risks are pretty straightforward. You're opening the door to the government. You're announcing your belief that a crime may have been committed by someone at your company. You're inviting civil litigation. You're inviting bad press, and you're in some ways inviting a lot of time and work and commitment. These cooperation arrangements that occur generally entail a lot of work by the company to respond to requests by the government and so forth. So you're really biting off a lot by self-reporting. The benefits, on the other hand, are also pretty clear, and the biggest one is this cooperation credit, and this is what Cody was alluding to earlier. The companies and individuals for a long time have received credit in the form of deferrals of prosecutions, outright declinations of prosecutions, leniency at sentencing for self-reporting. And that trend has only increased in the last year, under the current administration, where the new guidelines around cooperation, I think it's fair to say, have expanded the circumstances where cooperation credit is available and have made it easier to, in many respects, have made it easier to cooperate. One example is under prior administrations, in order to get cooperation credit, there was a real emphasis on waiver of the privilege. So companies would be required to turn over, in order to get cooperation credit, turn over what otherwise could be characterized as privileged material. That requirement appears to be gone in many of the new cooperation policies that we're seeing. We're also seeing not just a cooperation policy at the national level, at the DOJ, but individual U.S. attorneys' offices have their own cooperation policy. So recently, the Southern District of New York announced its own cooperation policy. So lots more to say on these issues. These are, again, very complicated, but wanted to flag some of the big picture items, and obviously happy to take up any questions that folks have either in this forum or otherwise. And I know Cody and Nic feel the same way. These are issues that we find extremely interesting and challenging, and so happy to take the time to dig into them further. And with that, I'll thank everybody for being here, and thanks to Cody and Nic for their terrific presentations. And I think we'll wrap it up there if there's no questions. Let's see. So, question: any thoughts on whether how the U.S. v. Hepner holding would apply in that same situation before that judge, but the subject conducted searches via traditional web browser such as Google, having not reviewed that case myself? That's a great question. Like, I had not read the decision myself, so maybe I'll defer to somebody who has. But it's an excellent question. Like, what's magical about the fact that it's AI?
Well, and it's the opposite, right? I think defendants have got themselves into trouble with Google since Google was invented. You've all seen the government introducing evidence of Google searches about whether I could be in trouble for hiding the murder weapon under the car. Like, that has always been a problem. The difference, I think, is that people interact differently with AI platforms and feel, for whatever reason, as though they have a more private, personal, confidential relationship, and engage, in my limited experience, with more back and forth. And so I don't think the disclosure risk is different. I think your Google search history is prime target for the government in criminal cases. I don't think the disclosure risk changes, but I think the substance that people are willing to get into and disclose on one platform is materially different, and so the risk is greater.
Yeah, I think also the output, right, is different. You wouldn't necessarily run a Google search and then send the results to your lawyer with the expectation that that would be privileged. Whereas I think what happened here is the defendant, again, having not read the case, but I imagine what happened is the defendant runs his queries through the AI engine, and then the substantive result that comes back he believes to be privileged because he's sending it to his lawyer.
Yeah, although Judge Rakoff looked at that argument and said, not a lawyer. The AI bot is not a lawyer.
Right. Great.
Thanks, everybody. I echo Brooks' thanks. Good to see everybody, and we're here if anybody needs anything.
Thanks, everyone.